much for joining us today. I'm really excited to have Mary Guzman from Crown Jewel Insurance here with us to talk about trade secrets. So I just wanted to read an introduction, Trade Secrets Insurance. I just wanted to read an introduction, which I think is an absolutely stellar introduction from probably the godfather of trade secrets in the United States, Mark Halligan, who's a trial lawyer and intellectual property litigation expert at Fisher Broyles. And he said, well, the trade secret asset insurance puzzle has now been solved. 80% of the new US economy has been solved for. Mary's credentials are impeccable. 28 years, I don't believe it's 28 years, not like 8 years. In the insurance business, including development of innovative insurance solutions for large clients across all industries. Mary is an insurance guru who thinks outside the box. And Mary is now focused on the biggest gap in existing insurance policies, trade secrets. Mary's the founder and CEO of Crown Jewel Insurance, which provides a revolutionary suite of risk management services and insurance protection for trade secrets assets. Brilliant, Mary. Thank you ever so much. I'm now going to ask you to do the same for me. No, I'm not. So in the introduction, I came across as John Pryor, and I provide IP strategy advice and develop trade secret programs for companies in all sectors. And I combined business experience, vast business experience, and IP expertise to help companies compete and win with IP. And Mary was particularly intrigued, and it's relevant, I think, to our discussion today, are trade secrets the new patents. I was for 4 years, 2010 to 2014, the height of the patent monetization boom. I was an auctioneer and patent broker at ICAP, Ocean Thermo Patent Broker. So more about that later. But over to you now, Mary. Thank you very much for joining us. And where should we start? Do you want to start just by introducing, how you got to where you are today, and why you think, based on your expertise and really interesting experience in the cyberspace, that trade secrets are the next big thing, as cyber insurance was over the last couple of years?
Yes, thank you for that introduction. And I'm glad you're not using your auctioneer voice, because I'm not sure I'd be able to keep up. So thank you for that. I really appreciate it. And Mark's quote is very humbling and flattering. And I don't read that often enough. It's kind of a nice little ego boost, but I appreciate that. So the way I got here was essentially that the cyber insurance market, which I was part of going all the way back to 1999, when cyber very first came out. It was still just an idea really at the time, and that came out because of the Y2K scare. Everybody was worried that the world was going to shut down at midnight. It didn't, but there were all kind of precautions being taken, and I think it made those of us who had technology clients at the time realize that this was going to be a new thing, that computers could be shut down by viruses, worms, different types of attacks, and cause outages. So over the 24 years, really, that I worked on cyber insurance, we saw the market obviously start from nothing. And for the first sort of 7 years, myself and a handful of other people, literally a handful, there were 5 of us at Marsh at the time. We were the only broker that was trying to do anything at the time in the cyber arena, except for Sedgwick, early days. And we ran around the country trying to explain to clients what this risk was, what it looked like, why it wasn't covered by other insurance, and nobody bought anything for a long time. Then we started to see some regulatory change around privacy, personally identifiable information, and personal health information. And as soon as that evolved or came about, organizations that had those records, so those 2 sectors, financial institutions, healthcare, followed by retail, it was a very vertically integrated adoption of cyber insurance that kind of happened over a period of time. But it wasn't long, maybe another 4 or 5 years, that everyone started to realize that there could actually be really serious disruptions to their operations as a result of an outage, not a privacy breach. And so the cyber market evolved. One thing we were never able to get the cyber market to do as leaders in that space was cover the actual value of trade secrets or innovation assets, all the money that a company spends on research and development, all the wrong turns they made, which is called negative know-how. Oh, excuse me. We were never able to get them to cover the value of those assets if they happened to be misappropriated during a breach. So I set out to go do so, fill that major gap in the market 4 years ago now, by developing a policy wording that is completely unique around trade secret laws, taken a lot from the language that's included in the Defend Trade Secrets Act, the only federal statute in play, to try to fill that gap. And the biggest challenge I think we had was getting the markets comfortable that the valuation could be done in a reasonably accurate fashion, and that valuation then could be insured. And the only way we were able to do that was to convince them that we could put in sort of risk management tools that we would not only allow, but essentially mandate that clients or potential insureds adopt, at least in some way, shape, or form, so that we can check the boxes along identification, valuation, risk mitigation, all of the things that we need to see, and recognize that there needs to be a crisis management plan in place. It's very similar to what we had to do in cyber to develop the capacity in that market and get the underwriters and the market comfortable that we could write that profitably. And so I feel like we're in a similar spot. One thing that I think is really different about sort of trade secrets as an asset versus cyber as a risk in general is that, believe it or not, these assets are much more valuable depending upon the company. But some of this litigation is absolutely bet the farm litigation. And I think a lot of organizations don't realize how valuable their trade secrets are until it's too late. And so that's a really important thing to say, I think, number one. And number two, I think if organizations don't have a process in place to identify those assets, they're going to be out of compliance with some new regulatory things that are happening.
Yeah, fantastic. Thank you ever so much. And just, I think it's really important that we clarify that trade secrets cover both commercially valuable information and inventive information. And there's sometimes a misunderstanding, and people think, well, it's either a patent or a trade secret, and trade secret, all patents start out as trade secrets, and then they can either become patents and or trade secrets, and both, as it were. But commercially valuable information such as customer lists, profitability information, M&A discussions, and so on, is also incredibly valuable. And I think it's fair to say that's where most of the litigation in Europe has been, on the commercially valuable information over the last couple of years. But let's just step back and look at patents, because if trade secrets are indeed the new patents, we need to give some reasons for that. And my experience, I go back to the days of being a broker, and at those times, value connected to patents was particularly strong. And then we had the American Invents Act, and a change to the way things ran in the States, and PTAB courts, and so on and so forth. And now, in the latest figures, I think I'm right in saying 2022, 70% of all those patents that went to court in the States and were challenged before the Patent and Trademark Appeals Board, PTAB, 76% of their claims were found to be invalid. And only 19% of patents escaped unscathed from that process. So, my very simple English, it's the teacher, the USPTO, marking your homework 5-10 years after they gave you an A star, and they're giving you a D or a D minus. And this is just really difficult for people to get their heads around. But of course, it introduces a whole new complexity to managing inventions and protecting inventions. And you can no longer rely solely on patents. Well, you could, or even so back then, I'm not quite sure either. But it really brings into sharp relief that you need to have other forms of intellectual property, such as trade secrets and other forms, copyrights, designs, and so on and so forth, to protect your IP. So So really important. And so that coincides, of course, with the evolution. Marion, please jump in. Over the last 6 to 8 years, as you said, the DTSA, Defend Trade Secrets Act, I think it was 2016, and then we followed quite quickly by Europe and the UK and Japan and China, all upgrading once, if not twice, their trade secrets legislation. Means that now we've got it's an old form of IP protection, but it's a much more powerful form of IP protection. In the US, it's criminal. It's criminal. It's a criminal law. In the UK, they just changed it last year, last October or July, I can't remember. It's criminal law for state-sponsored trade secrets theft. So it's changing all the time, and case law is evolving all the time. But it's fair to say, from where I stand at least, that the trade secrets are a fundamental part of intellectual property protection and a fundamental part of invention protection, far more so than they were 10 years ago, without any doubt. And it's changing and improving, increasing all the time. Mary, over to you.
That's okay. Yeah, and I think to your point earlier, I think a lot of people don't recognize that patents start out as trade secrets. Anything in an R&D pipeline is by definition a trade secret as long as it was independently developed. You put specific protections around it. It provides value to the organization. So the earlier in the R&D life cycle, the less you can ascribe to its value because you don't know how well it's going to do and what the commercial viability of the product versus what your competitors are doing, et cetera. But as you get further along in that pipeline, the asset theoretically becomes much more valuable, and you see the projections down the road of how much revenue that might generate or what kind of efficiencies that's going to bring your organization. And I think a lot of people don't recognize, as you talked about the commercially viable trade secret information as opposed to technical trade secrets, that a lot of the most valuable trade secrets are efficiency plays in your logistics and supply chain function, or how you design and implement processes in your manufacturing facility, et cetera. IoT devices, all of those kinds of things. And you think about critical infrastructure and tech and telecom and utilities and green energy and all kinds of organizations that are using operational technology and IoT devices and recreating and rethinking the way they're doing their manufacturing or distribution of their products. So it may not translate into direct sales going forward, but it's still a super valuable asset. The other thing I think is that a lot of people maybe don't recognize that if you decide not to put a value on whatever asset that you're developing, that it makes it harder to determine what kind of reasonable measures you need to take. And I'm certainly not suggesting that you have to put an exact dollar value on everything in your R&D pipeline, because that would be a really difficult task. But certainly your crown jewel assets that are in your R&D pipeline or trade secrets that are already commercially viable, if you've got at least some sense relative to each other, or a solid estimate on how much those are worth, then you can assign the limited resources you have from a cost and personnel standpoint around those assets. And I think that's a really valuable thing for people to think about.
And Mary, I know one of the pushbacks you get most frequently is, should we list all of our trade secrets, and what if we miss something? What's the issue there? What are people worried about when they make that statement?
So the overarching theme to that argument, I think, is that if we have a list or a registry of trade secret assets and we accidentally leave some off, we're not correct in capturing absolutely everything we're doing. That happens to be one of the assets that walks out the door when a team goes to work for a competitor and we want to bring a damages claim or try to get that asset back using an ex parte seizure. It makes it easier for the defense in that case to say, well, it must not have been a trade secret because you didn't list it on your list registry. There are a lot of ways around that. I think a lot of lawyers that I talk to and my own experience in insurance is that anytime you're creating a list of assets and ascribing a value to them, there's a chance that you're going to miss something, whether that's other types of data that aren't trade secrets or pieces of property or whatever the case may be. As long as you have a process that attempts to grab certainly the most valuable trade secrets, starting with that at the top, then you just simply say this is not an exhaustive list. It's an ever-growing and changing list of assets, and we try our best to monitor it. And here's the process we've implemented. As long as it's reasonable, it should stick. So that's my thought on that.
Yeah, great answer. And I just wanted to touch on AI as well, because the world is being eaten by software, or software is eating the world. Mark Andreessen. And with AI, there was a recent breach at Google, and somebody said 15 years of highly sensitive AI code had been stolen, misappropriated, and there will be subsequent court cases and so on and so forth. But I find that really, really interesting, because the value there, we're probably talking billions. And then, Google again, last week or 2 weeks ago, somebody leaked deliberately some of the Google search algorithm, and that was from 1996, and clearly it's developed and changed over those ensuing nearly 30 years. But the point is, if you tried to protect it in 96 with a patent, that patent would have expired in 2016, meaning you didn't have that protection post that event. And so, expiry of patents is another reason why, if you can keep something a secret for a long period of time, then retain it as a trade secret. And clearly, those two. Go on.
I'm sorry, and I was just going to say, generally in AI, on the topic of AI, there's a lot of discussion around generative AI, the output of it being potentially only protectable as a trade secret because it's not invented by a human. And patent and trademark laws are designed to protect individuals who invent something. And so there's some case law precedent already in the US that says that patent and trademark law and copyright, for that matter, are not going to be applicable potentially to the output of generative AI if that output is secret, because the input that you put in that gave you the output that only you could get was secret as well. So it's going to be really interesting to watch how AI develops and changes things. I fully agree with that.
And I think just a final point on AI, which I think is relevant to the trade secrets becoming the new patents debate. The patenting process involves putting forward an application, and that application is secret, private, for 18 months, after which it is published. So there's a disclosure of your invention. The patent is disclosed. Now, you still, of course, have some form of protection, but not full protection. It's not yet granted, and that might take another 1 to 3 years, maybe longer, maybe 5 years to get it granted. And if you're going for several countries, then, So the issue you've got is nowadays with the generative AI engines, they can read that patent upon publication, build on it, and invent around it. And so by the time you get to grant, your competitor's gone round it. And so it's kind of interesting, but it's moved on. The inventive space has moved on. And I think this is a really important consideration, along with the other points we've made, from an IP strategy and invention protection perspective. And I just want to say, and I know you'd say the same, we're certainly not anti-patent. Patents form a fundamental part of intellectual property protection, and more so in the United States than anywhere else. But you cannot rely solely on patents. You have to have a blend of intellectual property rights now to protect the value in your business and your competitive advantage. So, Mary, I just wanted I wanted to move on, because there's two other really important things that are happening in the United States at the moment: the banning of non-competes, and then more recently, I think the SEC, the move into statute of the SEC regulations about clear announcements on the impact of a hack post attack. Because most people tend to try and keep that secret, don't they? There's incentives to keep it secret previously, but now they have to let people know, right?
Absolutely. Yeah, so let's take those one at a time. So the FTC ban goes into effect in September. It's an actual law. It's no longer open for public comment. I think there was some confusion about that. However, it is being challenged by multiple labor groups around the US who think that it's unconstitutional, or that the FTC didn't have the appropriate authority to pass this ban. We'll see how that goes. But at the end of the day, states are starting to erode what was really significant protection. And frankly, a lot of companies, I think, relied almost exclusively or very heavily on non-compete provisions in their contracts with their employees. If that goes away, suffice it to say that companies are going to have to do something dramatically different to protect those assets, which is switch the non-compete provisions to non-disclosure provisions, much like you would have with a third party who has access to your data, as long as they're not overly broad in the sense that it would prevent somebody from going to work and competing in a field somewhere else. That's the whole reason why the FTC passed this ban in the first place, was for anti-competitive reasons. California is a state where non-competes have been disallowed forever. And there are other states that have followed suit. Depending upon what happens with the federal law, we may see other states jump in or not. I think a lot of them were sitting in wait to see what happened with this federal statute. But certainly there are measures that organizations can take around intake procedures, training, certainly around what a trade secret is, having clients sign something, or employees sign something acknowledging that they understand that what they are inventing by and on behalf of your organization while they're getting paid by you belongs to you. And then you remind them of that again when they leave by doing an exit interview. There are lots of things that can be done to still sort of shore up that trade secret protection. But in my opinion, most of that does lend itself back to, you have to know what your trade secrets are first so that you can bootstrap those protections with specificity around what you're telling your employees to do. The second issue, which is the SEC ban, the SEC rule, in my opinion, I think is an even bigger deal. I might be alone in that, but I think it's huge. And a lot of people are sort of missing this connection. They're not connecting the dots. The FTC rule, which is in effect already, it went into effect in December of this past year, says that any public company in the US must tell their shareholders in their 10K and their public filings what they're doing to identify, mitigate, and essentially protect any asset that, if compromised, could cause a material impact to earnings. They did not define material. However, in their actual commentary, when they released the rule, as a side note, they said, we would expect organizations to tell us things that could impact their competitive advantage or damage their reputation. We're no longer talking about just PII and PHI and ransomware. We're talking about the keys to the kingdom. And the reason they're doing that is that most people are investing in publicly traded companies today because of some innovation asset. And if that innovation walks out the door and the value of the company tanks overnight, you're left holding the bag if you're a shareholder and you were none the wiser. They have an obligation to tell you. And I think that's what a lot of organizations are missing. Not only that, but if there is an asset that's compromised, you have to quickly identify what those assets are and make a determination whether or not it would have a material impact. In the cyber world, material impact is a very low threshold. It could only be 0.5% of assets or 1% of earnings, which is a very low threshold if you think about some of the crown jewels that companies have sitting in their R&D pipelines right now. If you recognize that a material asset has been compromised, you have 4 days to file an 8K. Telling your shareholders the specificity around what happened and what you expect the impact to be and what you're doing to fix it. There have been 7 companies so far that have filed 8Ks following an incident since this rule passed in December of 2023. And according to an article in Forbes and another article in Dark Reading, which I can share with people if they reach out and ask me for them, virtually none of the companies really followed the letter of the law. When they made their disclosures, they said, yes, we think we may have had a compromise of a material asset, but they didn't provide much color around it. In the Appian case, I think that's an example of something that I think is going to happen over and over again, where Pega actually was found guilty of trade secret misappropriation. They had a follow-on D&O claim that settled for $35 million. And that really arose out of the fact that PEGA told their shareholders that the claim was nothing to worry about, essentially. I think that's going to be a continued source of litigation as we move forward.
Yeah. And I think you know, a couple of quotes here. The value, as you alluded to at the head of our meeting here, is substantive. Some of the government analyses have shown that the value of trade secrets that are misappropriated from major industrial nations accounts for 3% of GDP. Now, if you sort of marry that with a recent survey done out of the UK, which showed that 43% of major companies didn't actually have a way of capturing trade secrets, nor a way of managing those trade secrets once they had them. That's 43% of companies, and then 3% of GDP. If you translate that to 3% of turnover or value, even, then we're looking at a substantial value misappropriation that's taking place. And Mary, you know, you use the words competitive advantage, and I think that's so important to bring trade secret theft, which seems a little bit, if I may, James Bond-esque, you know, a little bit out of my. It's not what we do. We don't do that sort of stuff, industrial espionage, etc. It's relevant for every single business. And I don't think people, you know, 43% aren't doing much about it. I don't think people have really accepted the size of this problem stroke opportunity to capture and nail down. What's the best way in your experience to communicate how important this is, to get people to set up and take notes and take action?
Yeah, we actually estimate this is well over a $5 trillion gap in insurance in the U.S. market. It's huge. I think that number is light on the value of trade secrets just in the S&P 500. So, you know, there's a massive opportunity for us to step up and help organizations. One of the things that we do is provide a questionnaire or different varieties of them that we can give to the in-house IP counsel or the CFO, depending upon sort of, or the COO, whoever's in charge, who can then distribute that questionnaire across different division or department heads to get them thinking about the types of things that could qualify as trade secrets, whether that's in your accounting system or your logistics and supply chain or your sales and merger and acquisition strategy or whatever it is, to sort of jog the thought process with senior leaders across the organization, who then can push that same questionnaire down to their people underneath them to get them thinking about what they're working on every day and the tools that they use. So training is really important on just exactly what is a trade secret and what do you have to do to protect it. One other thing that I wanted to mention is that in that PEGA claim I mentioned earlier, that the actual jury verdict came in at $2 billion with a B. You want to talk about a game-changing verdict against PEGA. The company value went through the floor. And so it's very similar to a case in Georgia that went to a jury recently. That was a former Alcoa subsidiary. Two people went to work for another company. The Alcoa subsidiary spinoff sued the new company for misappropriation of trade secrets, with saying that the employees took those trade secrets. Fast forward, the litigation lasted 8 years and probably tens of millions in just legal fees and discovery, not to mention that they were completely distracted. But the client, the new company, had moved Boeing, which was the only client of the previous company. So they were being sued for $260 million. The jury came back and said it wasn't a trade secret because you weren't able to demonstrate that you independently developed it. And we, as the jury sitting here 8 years later, were not able to ascertain for ourselves that it wasn't just known in the industry, which is what the defense had said, that this was known in the industry, it wasn't a trade secret, and that they marked hundreds of documents as confidential 10 days before the suit was filed. So that was kind of a reasonable measures issue. But I wouldn't be surprised if that company filed bankruptcy. That's what a big deal these losses can be.
Yeah, and as you said, there's so much case law coming through at the moment. I'm going to try and capture what I think is important, and you can fill in the gaps where I make a mistake. But it's really important for businesses, for companies of all sizes to identify their trade secrets, to value or put them in some form of category, high, medium, low, manage them ongoing. And that means to some extent training employees so they fully understand, marking trade secrets as, not everything's confidential, otherwise nothing's confidential. But, this one is a trade secret, this one is top secret or whatever. So it's very clear. Making sure that employees have got contracts coming in, as you said, that everything you create here is as, and as they leave, a reminder, by the way, everything you created here is as, you can't take it with you in your head or otherwise.
And they need to buy insurance.
And they need to buy insurance. So I was going to say, so all of those things will qualify them for insurance. Is there anything I missed there that's that we need to add on to that list?
I think you pretty much captured most of it. The only other thing is your responsibility and your obligations with third parties who you might be co-developing technology with, or that how you've licensed trade secret information to, and what those non-disclosure agreements look like. One thing I think a lot of people sort of overlook is that trade secrets are trade secrets basically forever, as long as they're secret and continue to add value. So if you're letting somebody have access to that trade secret information, then the confidentiality provision in your NDA around those trade secrets needs a survival clause. It needs to survive the end of the contract so that they're protected forever. That's the only other thing that came to mind immediately. But it is, I was tongue in cheek talking about the insurance, but it is the thing that a lot of boards of directors and organizations do to check the box on a lot of other requirements coming out of the SEC and other places like cyber. If you're sitting on a public company board, your company's got cyber insurance today. And again, I think these assets are just as valuable most of the time, if not more valuable, than the cost to respond to a privacy breach.
Yeah, completely agree. And I suppose in closing, we are increasingly finding that investors and lenders are asking the question, do you have trade secrets? Yes. Can you show me the list? Have you got a metadata description of what they are? Sure, here it is. And that starts to give, confidence. Oh, they're on top of this. They do manage this. Because you'd be surprised how many companies don't really have a comprehensive list and are not able to respond to that. And that illustrates to somebody in the due diligence process that possibly they're not that well managed. And that's the last thing you want at that stage. So Mary, maybe we should just give you some wrapping up comments, because I think we're sort of reaching the time now. But this has been brilliant, and I would dearly like to do this again, because this is a fast-moving space, and we should hook up together in a couple of months or so, and do the same again with some more additional information, if that's that party to you. But any sort of final comments from you?
Yeah, I guess my final thought would be that the exposure on trade secrets is dramatically increasing because people are spending 30% more in the tech space, in particular, year over year in R&D than they did before. A lot of today's assets are not patentable. Just the top 10 companies in the NASDAQ spent $222 billion in R&D in 2022. 10 companies spent that much money. So you think about how many assets out there that are not protected. So the exposure is increasing for sure. The protections that have been in place for a long time are being eroded or being challenged, let's just put it that way, in terms of just using the hard hammer of a non-compete, and or being able to go to a judge and say, well, I don't know what my trade secrets were or what went missing, but can you give me 2 years to go backwards and do discovery? Judges are saying, nope, we need to know right away what the trade secret is, or we're not going to let you even start the discovery process. And then the third thing, other than increased exposure and eroding protection, is that insurance is available now. I think that's a really relevant thing in terms of, helping protect, unfortunately, not your balance sheet per se, because these are not balance sheet items unless bought during an acquisition. But I think, potentially the accounting rules will change on that. And in any event, we are starting to get some inquiries around loans on the back end of the value of these assets that are insured, which is exciting.
Yeah. Sure. That's great, Mary. Thank you very much. Now, how do people get in touch with you? They can find you at Crown Jewel Insurance for sure, and on LinkedIn. What's the best way for them to reach you? Come onto the website and find your details there, or?
And my phone number is 404-290-8155. My email is mguzman@crownjewelinsurance.com, or you can email Kate, kgingras@crownjewelinsurance.com, and we will definitely get back to you.
That's brilliant. Thank you very much, Mary. And I've been John Pryor, and you can get me at john@exaltip.com or on LinkedIn, or country code 44 7587 885 131. There we go. Phone numbers all around. Mary, thank you very much.
Thank you, John. Good to talk to you.
So lovely to speak to you, and we will speak again soon. Take
All
care.
righty.
Bye now.
Thanks. Okay, bye.